For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So,
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
so have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh. I'm going to stop you right there. And I want you to hear me clearly.
All right, everyone. Today, we're looking at a courtroom moment where a self-proclaimed sovereign citizen steps in front of Judge Boyd. But this hearing takes a very unexpected turn. Instead of responding with frustration or the strict approach we often see judges use in these situations, Judge Boyd chooses a completely different strategy. She meets the defendant with patience, calm explanations, and a level of kindness that almost feels strategic. It's as if she's approaching the situation like a high-level chess match, staying 3 moves ahead while the sovereign citizen struggles to keep up. Her tone stays steady. Her reasoning stays clear, and every answer she gives seems designed to keep control of the room without raising her voice. As you watch, pay attention to how her demeanor shifts the entire energy of the courtroom. It's rare to see a judge navigate a difficult interaction with this much composure, and the result is surprisingly effective. Let me know what you think about Judge Boyd's approach, whether her calm strategy makes the situation easier to manage or creates an even stronger contrast with the defendant's behavior. Now let's jump in and watch how Judge Boyd carefully breaks down each of his arguments and maintains order in the courtroom with nothing more than patience, clarity, and firm professionalism.
How's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself. But here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I am the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974. State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
Right.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh,
The moment the defendant insists the court has no authority, Judge Boyd pauses and responds with controlled calmness. All right, since you're saying you don't understand, we'll move forward with ordering a competency evaluation. Her tone is steady, showing she's prepared to handle confusion without escalating the situation. Honestly, watching interactions like this makes you wonder if the legal system should eventually introduce some kind of standardized process for self-represented defendants, especially those who follow these sovereign citizen theories. Imagine if there were a brief, required assessment that ensured defendants truly understood courtroom procedures before being allowed to argue their own cases. It could save time, reduce confusion, and help the court function more smoothly for everyone involved. It's not about restricting anyone's rights. It's about making sure they actually understand what they're walking into. Some individuals genuinely believe that declaring themselves outside the court's jurisdiction will somehow stop a judge from issuing a ruling, even though that has never been how the justice system operates. The Constitution already outlines due process and the framework that courts follow. No stack of printed documents or unusual legal phrases changes the fact that state and federal laws still apply. And every judge, including Judge Boyd, has seen enough of these cases to know that the law remains consistent no matter how creative the argument may be. Moments like this really highlight why clarity and proper understanding are essential in any courtroom. A grounded approach, like the one Judge Boyd uses, helps ensure the process stays fair, orderly, and focused on the actual legal issues at hand.
means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right. So let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sorry.
All right. We're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
This defendant just keeps creating more problems for himself with every response he gives. It's clear he's losing control of his own statements, and each new explanation only adds to confusion he's already created. Judge Boyd has already explained the charges in a straightforward way, making sure he understands exactly what the court is addressing, yet he continues acting as if none of it applies to him. It almost seems like he believes delaying the discussion will somehow make his argument stronger, or maybe he thinks his rehearsed sovereign citizen approach will eventually force the court to back down. But as the hearing goes on, it becomes obvious that the strategy isn't having the effect he expected. Instead of supporting his position, it's only weakening his credibility and making the situation more complicated than it needs to be. What makes it even more concerning is that he's behaving as though the facts presented in court simply don't exist. He was told the charges directly and openly, but his reaction suggests he's treating the entire process like a performance rather than a legal proceeding that has real consequences. And there's a major issue he may not be considering. Giving false statements or denying facts under oath can fall under perjury, which is a very serious matter in any courtroom. Judge Boyd has made the information clear, yet he continues to contradict it right in front of her, which puts him in a difficult position legally. If he keeps going down this path, he may face even more trouble than he started with.
Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
admiralty or
to
military
counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
Yes, ma'am.
Thank you.
I'm usually not a fan of judges who take an overly gentle approach, because in many cases it doesn't seem effective, especially when dealing with sovereign citizen defendants who often rely on confusion and disruption. But in this situation, Judge Boyd is proving that calmness does not equal weakness. She isn't passive at all. She's simply composed, deliberate, and fully in control of the courtroom. Her steady tone and measured responses seem to work remarkably well here. Instead of escalating the tension or meeting the defendant's tactics with frustration, she answers every statement with precision and patience. You can see that she's listening closely, analyzing every detail, and responding in a way that keeps the hearing focused on the law rather than the theatrics. What makes her approach stand out is how strategically she guides a conversation. She's not reacting emotionally. She's anticipating his next move and redirecting the moment it veers off track. The defendant, on the other hand, doesn't seem to realize how thoroughly she's managing the situation. He believes he's steering the conversation, but Judge Boyd consistently brings it back to the facts and the legal process. T's almost fascinating to watch how seamlessly she maintains control without ever raising her voice. Every time he attempts to shift the focus or create confusion, she responds with clarity, grounding the entire room back in reality. Her experience and professionalism are on full display, and it shows how effective a composed approach can be in cases like this. Let me know what you think. Does her method seem like the smartest way to handle a difficult defendant? Now, let's get back into the hearing and see how she continues navigating this unusual exchange. School.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
School. I'm not entirely sure why the defendant is smiling through this hearing, especially after choosing to act confused earlier in the process. His sudden shift into a friendly, casual tone with the judge feels noticeably out of place. It's almost as if he's trying to undo the impression he already created. but the change in demeanor doesn't match the seriousness of what's happening in the courtroom. Then he asks if it would be possible to move the court date, which raises even more questions. The timing feels unusual, almost like an attempt to delay the case or find a way around the responsibilities he's facing. What he may not realize is that postponing the process without a legitimate reason rarely helps a defendant in the long run. Instead, it often adds more complications and reinforces the appearance that he's avoiding accountability. Despite all of this, he continues smiling as if everything is going smoothly. It creates a strange atmosphere, one that feels disconnected from the reality of the situation. Whether it's nerves or a misunderstanding of courtroom expectations, it gives the impression that he doesn't fully grasp the potential consequences of his choices. And if he stays on this path, the legal process is eventually going to catch up with him. Judge Boyd, however, maintains the same steady professionalism we've seen throughout the hearing. She gives him multiple opportunities to stay on track, clarifies expectations, and guides the conversation with patience. Her approach shows both experience and restraint, and it's clear she's fully aware of the tactics often used in sovereign citizen-style arguments. Watching her handle the situation so smoothly really stood out. She stayed composed, kept control of the discussion, and ensured the facts remained at the center of the proceeding. In many ways, she demonstrated how effective calm leadership can be when dealing with a challenging or unpredictable defendant. This hearing was definitely an unusual one, but also a fascinating example of how a judge can manage a complicated interaction without losing focus or authority. I'd love to hear what you think. Did Judge Boyd handle the situation well? Did her approach work? Or would a firmer tone have changed anything? That wraps it up for this breakdown. Let me know your thoughts in the comments. I always enjoy reading your feedback and seeing how everyone reacts to these cases. If you found this commentary interesting, feel free to like and subscribe. There's new content every day, and I appreciate every one of you who takes the time to watch. Thanks so much for being here, and I hope all of you are doing well. Take care.